morning, everyone. My name is Adel Belushi, and I would like to welcome you to the Ministry of Justice and Legal Affairs. Today we have another session of the multi-lecture series in collaboration with the Omani British Lawyers Association, and it's delivered by Kennedy's. Kennedy's is an international law firm established more than 120 years ago. It has over 2,400 employees working in 22 countries. Their office in Oman operates in association with House of Assembly, advocates and legal consultants, and specializes in insurance and reinsurance, construction and engineering, commercial dispute resolution and advisory services, transportation, infrastructure, utilities, fraud, and cybercrime. I would like to now welcome Jamie, the partner in Kennedy, to the stage to introduce his colleagues.
Thank you very much, Dr. Riyad. Thank you all for joining us this morning and giving up your time. A very warm welcome to the Ministry of Justice and Legal Affairs. I'd like to say thank you very much to Dr. Riyad for inviting us here today to present this topic, and also to his amazing IT team that have set up this system that allows us to connect to our colleagues in Hong Kong and Dubai. Now, obviously, when you thank the IT team for that, if it goes wrong, they get the blame, not me. Anyway, a very warm welcome. My name's Jamie Kellick. I'm a partner at the Kennedy's Oman office. I'm here today with my colleague Amal Al-Raisi, who's an associate with us here in Muscat. And joining us from Hong Kong is Joni Ko, who you can see on the screen. She's a partner in the Hong Kong office, and she's the head of the cyber and data team for Kennedy's for our APAC region, which is Asia Pacific and Australasia countries region. And last but no means least is Kelsey Evans, who is an associate in our Dubai office. And all of us together are part of the Kennedy's global cyber and data team. Right, let's start the presentation. Here, this is a trajectory of the number of ransomware incidents and amounts of money made by ransomware threat actors in the past few years. While you can see there's been some flattening of the curve due to the decreased activity as a result of the Russian-Ukrainian invasion, experts expect this to be temporary only. In our experience, the cost of dealing with data breaches increases exponentially in relation to these attacks, and also in particular when there is data notification requirements that come through. And as we all know, that's going to happen in Oman in February of next year. So today, Joni and Kelsey are going to talk you through how to manage the ransomware incidents, and then myself and Amber are going to deal with the notification requirements, and then cover off the points of the newly introduced personal data protection law in Oman. So, playing the anchorman, I'm going to take you live to Hong Kong and over to Joni. Thanks, Joni.
Thanks, Jamie. The frequency of ransomware incidents is certainly a concern for most businesses. But, how much are we talking about? How big is this ransomware industry, and how much do people pay as ransoms in 2021? So let's say yes, is it $200 million US? 500 million US dollars. Well, $500 million US dollars is very close. Reports are telling us that it was $600 million US dollars paid in ransoms in 2021. Now, this figure is made up of average ransomware payments, which reached almost $500,000 per incident, and starting ransom demand can be as high as $2.2 million US dollars. So if, unfortunately, you are a victim of a ransomware attack, those are the numbers that you may be faced with, and that's not even including the costs of dealing with an incident. So let's talk you through how we manage incidents. You might hear Kennedy's being referred to as the breach coach or the incident response manager, and that is essentially our role. We coach companies through the incident that they're suffering, we manage it for them, we help with containment, and we assist the business in recovery. So let's imagine that you are a part of this business, 24/7 Printing International. It is an international printing business with offices around the world, but headquartered in Oman. It prints newspapers, magazines, but more importantly, it also prints time-sensitive documents such as prospectus documents that companies need to issue when they are raising funds in a public offering. You are a board member and you've not experienced a cyber incident before, but if it does eventuate, then you, as part of the board, are going to be the one who needs to make the important decisions. Unfortunately, on Thursday evening, just as everybody is closing up and trying to get home, all your workstations are showing this screen. All your employees are waiting for Windows to reload, but nothing really is happening. And then this happens.
So now you've seen a ransom note that is blasted across all of your computer screens by crazy snakes who are the threat actors against 24/7 Printing, your company. All your systems are locked and they are requesting 20 Bitcoin within the next 7 days in order for you guys to regain access to your data and systems, and that is around $400,000 US. Like I said, all the systems are encrypted, so your whole entire IT infrastructure is down, and everything including computers, emails, servers is locked, and there is no access to anything. So now we really need some help. 24/7 Printing need to call the Kennedy's Crisis Hotline, which is a UK number, as you can see, and that's where we have our central hotline, and then it will be diverted out to whichever jurisdiction needs our assistance. In this case, it would be diverted to our Oman office, and they would help you with the incident. Now, the first port of call in an incident response would be to come to the legal team, which is us, Jamie, Amal, Joni, and I. And we would advise on things such as regulatory authorities, so notifications that might be needed to a regulator, so that could be the data protection regulator, or it could be the individual regulator for your company if 24/7 Printing has a separate regulator for their business activities. And also any notifications required for employees or customers that may have had their data access during the incident. We will also advise on response strategy and coordinate with the different teams within the wider response team. And we will advise on any potential exposures to claims arising out of this incident against 24/7 Printing. And finally, the legal team will advise and assist with any negotiations with the threat actors. And that is something that if it is delayed, and if there is any delay in dealing with the threat actor, then potentially that could have a negative impact against the amount being requested. Now, the next step in incident response would be the IT.
So a lot of the times the question that we get from our clients is, do we go to our existing IT suppliers, or do we need someone who is a specialist in their field of IT? And whilst your existing IT suppliers can provide you with the hardware, so for example, if you need to replace servers or replace workstations, when you're faced with a cyber incident or a ransomware attack, we do need to deploy special forensics firms, because their role is essentially to secure your system. So what are they going to do? They're going to contain and expel the threat actor, because they need to search your systems to see if the threat actor is still operating in your environment. Are they still trying to do anything bad? Are they still trying to spread malware? So they need to do that. They will assist to secure the environment so that you are not going to be subject to a continuing attack. But they also advise on how to isolate systems. because when you have a network IT structure, one account that has been attacked by ransomware can actually spread that through other workstations via the network. The other thing that they will do is to help analyze the scope as well as the cause of the incident, because if you know how it all happened, then you can plug the gaps and make sure that it doesn't happen again. And identifying data exfiltration is important as well, because the threat actor might have been in the environment for a while, doing a bit of reconnaissance, having a look to see what data they could steal, which would be important to you if it is lost. So they might have done that before they launched the ransomware attack, and it is important to figure out whether they've taken any data, and if so, what it is. They could have taken confidential company information, but more worryingly, they could have taken personal data, which you have an obligation to protect. Now, often you can identify whether data has gone out in an unusual way, but it is often difficult to identify precisely what personal data has been taken. Threat actors that steal personal data may also threaten to publish that personal data, and the point of that is to put pressure on you to pay the ransom that they're demanding. So a tactic may be to announce to the world that they're about to release your personal data because you have been a victim of their ransomware attack. That is to invite a media response, media reporting of the incident, and often when that happens, the consideration for us is whether to get a public relations team to manage the media response and to contain the messaging. Now, a lot of the messaging we think about is, press releases, social media announcements. What do we say to the outside world about what's happening internally? But a lot of the messaging needs to take place internally as well, because your employees probably would not have suffered from a ransomware incident before. They're probably stressed by the fact that they can't access their systems and they can't continue business. So a lot of internal messaging needs to go on to calm the employees, to make sure that they are confident that the incident is being contained, and also to streamline the responses that the employees might be making to their customers. They might have customers calling them every hour asking what's going on. So if we do engage PR consultants, we would work with them to prepare FAQs so that employees can follow the FAQ and find out actually what is happening from the FAQ, but also follow the FAQ when dealing with external customers and media if they reach them.
So now it's 24 hours later, you've instructed your response team, the legal team, IT team and PR consultant are in the background, getting on with the work and everything that needs to be done. And unfortunately, we've now found out that your entire backups, 24/7 systems backups are encrypted and you can't access anything at all, which is really, really bad for 24/7 printing, because now key printing deadlines have been missed, including the company prospectus that was needed for Friday morning. And this is now really, really concerning 24/7 printing, because all production is completely suspended. A complete rebuild of your systems will take weeks, so up to a month, and clients are threatening claims.
So unfortunately, as we predicted, the ransomware threat actors have decided to announce to the world that we've been subject to their attack. And it's to put pressure on us to pay the ransom that they've demanded. So if you recall, there's 20 Bitcoin. They've now said to us that that demand has increased because we haven't contacted them in time, and now that demand is 40 Bitcoin. So they're increasing the pressure on us to pay. They're releasing information to the media, and we've got clients calling all our employees to say what's going on. The board is obviously stressed out, and if not stressed out already, it's gotten even worse because of all the internal and external pressure as regards whether to pay this ransom at all. So some of you on the board want to pay the ransom, they want this to stop. Others are not so sure whether they should be paying the ransom, are there legal implications? But all in all, they want to think about paying the ransom in order to get what we call the decryption key. Because the point of the ransomware attack is to encrypt your systems, and the threat actors hold the key to unlock your systems. So essentially, if you pay over the ransom, you're wanting to get that key back so that everything is unlocked and you can resume your business. So the question then is, should we be paying the ransom? Now, there are quite a lot of considerations. Firstly, we know how much the ransom is. It's 40 Bitcoin, so I think that's around 850,000 US dollars. It's not an insignificant sum of money, but at the same time, your business is losing money because clients are threatening to stop your contracts and deadlines are being missed. In fact, there are quite a number of considerations when thinking about paying the ransom. We talked about the pure economics of it. So, for example, if your business is losing 100,000 US dollars a day, but it costs $50,000 to pay the ransom, then when you do the maths, maybe it should be paid. But once it's paid, will it solve the issue? Will our systems be decrypted like we think? Now, threat actors are increasingly reliable in the sense that when you pay over the ransom, they will deliver what they said they would. They would deliver the key, which will help you decrypt your systems and hopefully get the business back up and running quickly. However, there are times where the threat actor may not cooperate, so they may take your money and not deliver the key, or they may take your money and deliver a key that is not as operable as we would have thought, or once you use the key, it's not that easy to use it. It doesn't recover the system as smoothly as we thought. The other issue to consider is whether we should be paying the ransom to criminals, because at the end of the day, we are dealing with criminals, and there's no guarantee that they'll deliver on the promise that they've given us. And if the public or the media find out that we're dealing with criminals and we're paying an extreme amount of money for this ransom, what kind of press are we going to be faced with? Are we going to have to control the messaging there? But at the end of the day, we need to think about whether paying a ransom is legal or not. Is it prohibited? Now, if it's not prohibited by law, then theoretically we can pay the ransom, but we would need to check whether the recipient of the ransom is actually a sanctioned entity or is it a terrorist financing entity, because there would be legal implications, legal ramifications of paying such an entity. So we do need to do thorough checks on who we are paying. We need to do the best due diligence we can to ascertain whether we're paying a sanctioned entity or a terrorist financing entity. Now, you may have thought through all of that and thought, well, okay, I still want to pay because my business is not functioning. I want to get my business up and running. So you said, okay, I will pay 40 Bitcoin. But the thing to note with ransoms is that threat actors will always insist on the ransom being paid in cryptocurrency. And with cryptocurrency fluctuations that can either work in your favor or against you, it may well be that you had thought that you are happy paying, 800,000 US dollars in ransom, but by the time you actually pay, that cryptocurrency might have increased in value and you're paying up to $1 million US dollars for the ransom. So that goes back to the economics of it. And there is also the concern that once you do pay and the public knows that you've paid a ransom, does that invite further attacks from other threat actors who think maybe you're a soft target? If I'm a threat actor and I know that you have a propensity to pay, then maybe I'd want to launch an attack on you, because that gives me some comfort that the work that I've done in attacking you will result in an ultimate payout.
So I guess the question on the board's mind at 24/7 Printing will be, how much is all of this going to cost 24/7 Printing to respond to this incident? So the first thing that we would consider is the fees for the response team. So that includes the lawyers' fees, the IT forensic team fees, and the PR consultants if they are engaged. Their fees altogether for the total response team are usually around 300,000 US dollars, if not more. And then, as Joni was saying, the ransom payment, which got increased from 20 Bitcoin to 40 Bitcoin, is now 850,000 US dollars. But like we said, that could potentially be negotiated if we assist with the negotiations.
Yes, that's right, Kelsey. With negotiations, when we do want to negotiate to pay a ransom, a specialist ransom negotiator will try and reduce that amount as best they can. They will have statistics as to how low they're able to negotiate it down. And oftentimes we're talking about 20, 30, 40% of the ransom demand is what is ultimately paid. But apart from the fees of the response team, the ransom, if it is paid, the other exposures are third-party customer or employee claims, because there is a risk where data is taken that data might be misused for financial fraud. And if you've got employees whose credit cards or identity cards are being used for identity theft or other fraud, then they may have claims against the company arising from the incident. The other exposure is obviously business interruption, because if after 24 hours, 36 hours, how many hours, your systems aren't able to be restored and business doesn't continue, then there's lost profit and potentially increased costs of working around the incident. There may be lost contracts because clients are worried that you won't be able to deliver on time and they switch to another printer. And if there is an investigation into the data breach incident by the relevant regulator, and they've found that there are breaches in the way you've secured or protected the personal data, then 24/7 might be subject to regulator fine. So if you add up just the first two lines, it's over $1 million US potentially. So all in all, we're definitely looking at amounts of over $1 million US for management of the claim, as well as third party and other claims. So apart from the costs, it can take weeks for 24/7 to recover. Those weeks have passed and we're at a stage of recovery. With the assistance of us, the incident response provider, and the forensic investigators, we've identified weaknesses and ways in which the systems can be improved for a more secure environment for the future. So after an incident, we always assess what's happened and look at the lessons learned and look at ways in which these incidents can be prevented. It may be that you need to ensure that your backups are on the cloud so that they don't get encrypted at the same time as your workstations. The other thing that can be done to transfer the risk of cyber incidents or data breaches is to purchase cyber insurance. So cyber insurance usually will provide cover for first-party loss, so your cost of dealing with the incident, as well as third-party loss, which is if you're faced with a claim by a third party. The cyber insurance program will usually give you access to experienced incident response providers such as Kennedy's, who have a global network that they can tap into to assist wherever your incident may be, as well as to advise on data privacy obligations. So at Kennedy's, we have numerous offices around our global network, and we operate what we call a hub notification system. So if an incident comes in and it is discovered that there has been a data breach in Oman, in Australia, in different parts of the world, what will happen is that if I'm sitting in Hong Kong, I will contact Jamie in Oman for all the advice that I need in relation to data privacy obligations in Oman and in the UAE. So we provide advice on requirements as well as obligations. And now I'm going to turn it over to the experts on the ground, Jamie and Amal, to tell you precisely what those obligations are under Oman law.
Hi, everyone. Thanks, Joanne and Kels. Okay, during the next couple of minutes, I'm going to take you through
Slides.
without notes. Okay. Okay, I'm going to take you through breach notification. But before going into breach notification, I wanted to ask a question. How many of you in this room experienced data breach? Can you please raise your hands? Okay, it's a small number. We can do something. Can you just grab your phones, all of you? Even you, Jamie. And go to the browser. I'm going to give you a link to check. No, it's not scary. It's something that the IT guys usually do.
So are you talking about personal data breach or like enterprise data breach?
In general.
Yeah.
Yeah. So there is this link, HAVE.
But we don't trust you.
No, trust me, it's okay. The IT guys told me about it, so it's safe. So there is this link which you can put your email address, which you're using everything, and it can show the websites which leaked your data. So it's HAVEIBEEN Yep. pwned.com. So just put your HAVEIBEENPWNED.com. So just insert your email and you'll see the applications or websites which has data breach of your data. Did you get it? Yeah. Okay, now I'm going to ask you the question again. Who experienced data breach before? See, it's more than before. So, okay, you know some applications which breached your data. So I'm going to take you through breach notification. What is breach notification? It's entities providing the notification of the breach to the authorities, regulatory, and individuals, data subjects. In this notification, breach notification, they mention the description of the breach, the information involved in the breach, what the entity did to investigate the breach, and the procedures and measures taken to reduce the harm on the data and the data individuals, and how they will prevent further breaches. So we'll go to the next slide here, and again to the 24/7 example, identifying notification requirements. The first thing we need to know is which jurisdictions does the client exist. Here, in which jurisdictions does the client offer goods and services? And also we need to know the jurisdictions, what are the mandatory requirements for notifications in these jurisdictions. Also we need to know, is it severe enough to be notified? Because in some jurisdictions, it's mandatory to be severe. So we need to know, is it severe enough to be notified in that country? And what are the time frames? I'm gonna take you through the next slides, which explains further. For example, here, the mandatory notification requirements for the GCC countries. In Oman, we need to notify the authorities, which is Ministry of Transport, Communication and Information Technology, and we need to notify the data subject, the individual, the victim. The notification is required if this breach leads to destruction, to processing, disclosing the data. And in the UAE, the same is, it's mandatory to notify both authorities and individuals. Here, the mandatory requirement is if it prejudices the privacy and confidentiality of the data. For Saudi Arabia and Qatar, they both, the mandatory requirement is that it results to serious harm to the data and the data subject. That was, I was telling you right before now when I said depending on the seriousness of the breach. In Kuwait and Qatar, both authorities and individuals must be notified, but for the authorities, there is a 72 hours notification time frame. So since you know the breach, you need to notify the authority within the first 72 hours. But there are no like minimum mandatory requirements.
So this is the obligation under the data protection law in Cambodia?
Yes, for Oman, because the regulations are not issued yet. So we don't have like clear picture of the time frames and the details. But in the personal data protection law itself, it says it's mandatory to notify the regulator and the individuals for these acts, like unlawful destruction, alteration, disclosure, access, or processing of the data. Okay, here for the 24/7 example, the first thing to do to assess the breach, if it's severe enough to be notified, the first thing we need to know is was there any unauthorized access or unauthorized disclosure or loss of data? Then this takes us to the next step, to know that what type of data were included in the compromised data. Later on, we need to know the threat actors, which Joanne explained to us a couple of minutes before. And what are their next steps? Are they going to publish it, ask for ransom? So we need to identify these things. And then the next thing is we need to know if there is any risk or harm to any individuals if these data were misused or published. The last thing is to consider the specific criteria for notification in the relevant jurisdictions. As I just said, in Oman, it needs to be, the breach needs to result to unlawful destruction. So we need to check for each jurisdiction. And the last thing is notifying regulators, how we can notify regulators of the breach of the data. The first thing is to prepare base details of the incident, the background of the breach, when it happened, where it happened, what happened, who is involved, and what information were used. So all these details needs to be prepared in one certain form. Then we need to prioritize the jurisdictions. In Kuwait and Bahrain, as I just said, there's 72 hours deadline. So we need to check for the other countries if they're outside of the GCC. What's the time frame of notification? Is it 72 hours? Is it 48 hours? It's depending on each jurisdiction. So that we can prioritize not to miss any deadlines. And then we need to distribute the notification requirements to the regional hubs. The regional hubs will distribute the notification requirements to local offices. Local offices will prepare and submit the notification notification to the regulators in each jurisdiction. And then in the final step, the regulators might come back to us and ask us about further information or further investigation. So we need to respond back to the regulators. And I think Jamie can take it from here.
Thanks, Emma. Thank you, Emma. Oh, are my notes there? So now we move actually onto the personal data protection law itself. I think you've taken my notes. There's the law. Lovely, thanks. So the law was issued in February of this year. It was published in the Official Gazette on the 13th of February. And as it states in the law itself, it comes out exactly a year after then. So we're looking at the PDPL coming into effect on the 13th of February 2023, which, just to scare you all, is less than 6 months away, and there's quite a bit to do. The good news is the law runs to 32 articles, well drafted, very clear and concise. The bad news is there's some regulations on the way which we have yet to be issued. So the devil will be in the detail when these come out. Right, let's get going. The reason for the law. The reason for the law is very clear. It's actually set out in the legislation. Is that personal data, all of our personal data, every individual in this room, in the country and in the world under the related to Oman here, personal data may only be processed within a framework of transparency, honesty, and respect for human dignity. Which sounds pretty sensible, sounds very reasonable. I don't think there'd be anyone in this room here that would disagree with how they want their data, their personal data, used going forward. But then also the law goes further. Who does it apply to? All of us, every living individual. What are the exclusions? There are quite a lot of lists of exclusions in the law. So I've put in 3 here under Article 3, which is obviously protection, national security, public interest being the top one. There are others that you can check through what they are. What is prohibited? Any data, your data, relating to your genetics, your biology, your health, your religious and political views, remain yours. That cannot be collected, stored, or processed by anyone. That is your personal information, personal to you. Okay? And also minors. Their information cannot be stored, processed, collected, distributed, and so forth without the consent of their parents or a legal guardian. So pretty straightforward stuff as we go along. Here's the rub. Unlike other data protection laws that we've seen, and obviously myself coming from the UK, obviously know a lot about the European regulations, although the UK has now left Europe, they're still adopting the same legislation. The significant difference here is that in Oman, similar to the KSA and similar to the UAE, you must now obtain the express consent of the data owner, i.e. the individual, before you collect and process their data. Now, under the GDPR in the EU, there was kind of an inferred or inferred consent, and I'll give you an example. Now, obviously, being from the UK and being with a sort of a UK headquartered office, we are trained ourselves as employees to make sure that we comply with the GDPR. The GDPR says that if I was to meet any of you when we're speaking outside, having a cup of coffee or having a sandwich, and you hand me your business card, that is your tacit acceptance that you are actually giving me your personal details, so I can then contact you and market my services as a law firm. Okay? Here in Oman, under this law, that, subject to what the regulations say, is unlikely to be the position. You have to give your express consent to actually provide that I'm allowed to provide, process your data and then contact you. We'll see how that comes out in the regulations when they are, but that's the way we're looking at it at the moment, is that you have to tell us. And I'll go into a little bit more detail about the articles of that. Also, under the GDPR, data controllers and data processors often rely on what they have as legal justification, is that they can actually process, they have a legitimate interest to process the data, i.e. they don't actually have to ask you to process that data because there is some form of legitimate interest under those regulations. That is not in the Oman law. So if you have been trained, like I have, on the GDPR, you've now got to add to that training, and you've got to now look at what the Oman law is doing, because these are significant differences. So if there's one thing you bear in mind from this lecture, this is the point. So it's Article 10, and then Article 22 deals with how people can market materials to you. So that's worth a read. There's the wording of Article 10, and that's pretty clear about the written consent. Now, the personal data owner, i.e. the individual, okay, must be also notified by you if there, as we've discussed in the last hour or so in this seminar, whether there's been a hacking or an infringement of your data. So not only does the company that was processing the data or held the data that was hacked has found out that data has been released to a third party, it must now tell the regulator, being the Ministry of Transport, Communications and Information Technology, but it also must tell you as well if you're the data subject owner. So there's quite a few points going on here. Now, the law requires every commercial entity that's going to actually hold, control and process data to actually appoint a data processor and a data controller officer. Okay, that's going to have to happen, and it's going to have to happen next February. So start thinking about who that person is going to be in your organization. Okay. When that data processor, stroke data controller, starts processing information on individuals, this is what that person has to inform the data owner of. Again, and this comes back to what I was saying about Article 10, is about this express consent. Not only do you have to get the data subjects express consent, you've got to tell them exactly what you're going to do with it. And there it is. And you imagine that you've seen emails in the past where people are writing to you and saying, or you've seen articles in business literature saying, this is how we process your data. This is what we do with your data. And this is going to be the same here. And again, as I mentioned, the disclosure options. You've got to make sure that you know when you have to disclose breaches to the regulator, but also actually information that the regulator is going to ask you. So you need to check. The regulator is going to turn around at some point and say, we want X, Y, and Z. You're going to have to check the law, check the regulations, like I say, when they're issued, and think about, is this information that I should be giving to the regulator? And then if it is, pass it on. If there's a breach, like I said earlier, you're going to have to inform the regulator, and you're going to have to inform the data subject. And as Anwar mentioned earlier, the Ministry of Transport and Communications and IT is going to be the regulator for the PDPL. So complaints. In the law, Article 12, you as the personal data holder, okay, have been upset by a company that is processing your data without your consent. Maybe they haven't told you and you found out. You have the ability to go and make a complaint to the regulator, the ministry, about what's happened. Now, I'm going to come on to the level of what the issues from the complaint system comes later, but I just want to ask a question. Come the 14th of February next year, Does anyone have any idea of how many complaints we may think will be made to the ministry at that time? Now, it's an open-ended question because we've basically got no idea. But here's to put it into perspective. The Public Authority for Consumer Protection. This is the number of complaints they have received since 2018. In Oman, we like to complain. The CMA, the regulator of the insurance industry, these are the numbers of complaints they have received from individuals complaining about their insurance policy. Now, that complaint, I would assume, is that the insurance company may not have paid out for whatever reason. In Oman, we like to complain. Look at those numbers. So, any idea, come the 14th of February, how many complaints are going to start coming through to the ministry? Who knows? But if that's an indication, they're going to be busy. Well, here I'm coming on to that one, and that's a really important question, which luckily I've covered. So the penalties, okay, this is where it gets scary, and this will answer your question. Penalty section is set out in 24 to 30 of the law. Here are the few or the two that are important. Article 25. Here we go. Here comes the big cash machine. Whoever violates the provisions of Article 14, Article 14 being that I have to tell you that I'm processing your data and I have to tell you how I'm going to process it. And I didn't. I did not notify you and I didn't get your written consent to do so. I'm going to get fined 500 riyals per incident, minimum, possibly 2,000. You would imagine that if I keep failing to do this, that fine's going to go up to 2,000 riyals, okay? This is the central one. You've got to get your processes right about obtaining consent and what you're going to do with that information. Because if you don't, you are going to be fined 500 riyals. And what do we like to do in Oman? Complain, right? This is going to be the easiest one to probably prove that's been breached. And it's going to be the easiest one that's going to be knocked out. And you're smiling, start getting your 500 riyals ready. Now, but let's be serious. This actually goes up. Article 29, look at that figure. That's not a typo. That is 500,000 riyal fine. Okay, and that's in relation to Article 23 that talks about transfer of data outside of the Sultanate. Okay, be careful. That's a huge amount of money. Right, I wanted to go back to, that's the covering off the data protection law. We'll answer your questions in a second. I wanted to go back to what Joni mentioned about ransom, and obviously what Amal picked up on the notifications is about the ransom. And one of the questions, if I was sitting in the audience, I would be asking this is it legal to pay the ransom in this country? There are no express provisions. Unlike Australia, unlike Singapore, for example, there are no express provisions that it's illegal to pay the ransom to the threat actors. Okay, if it comes down to a commercial and ethical decision. However, the authorities would prefer you not to. So all data breach incidents in the Oman should be reported to the see I put capital C on the computer, to the Oman National Computer Energy Readiness Team, or Oman, what we call Oman CERT. And there's an email and a telephone number as well. Like I say, it comes down purely commercial and ethical reasons as to ransom. However, beware, as also Joni alluded to in her presentation, okay, if you are going to pay monies to a terrorist financing organization, you will fall under the Article 8 of what I refer to as the AML and Combat Finance Terrorism Law, the Anti-Money Laundering Law and the Financing of Terrorism Law. Article 8 provides that, provides money directly or indirectly to an organisation to commit a terrorist act or by a terrorist person or terrorist organisation. Sorry, can't even read my own scribe. Okay, that's the important bit. And if that does happen, and let's face it, if there's a threat actor, they're definitely going to be, or 9 times out of 10, they're going to be connected to organised crime, and there's a possible terrorist financing element on there. There are the penalties. we're looking at jail time. Okay, so be very careful on that point. That's me moving away from the data protection law, but that's where we are. So it comes into effect on the 13th of February next year. That is the day before Valentine's, just in case anyone wants to send me a rose or a card. But here's the question. Will Valentine's Day next year have a lot of broken hearts? Maybe not in the ministry, because they're counting those 500 riyals. Okay, over to Q&A. I love it when there's no questions and answers, because that means we've covered everything. Go on. Hi, how are you doing? Oh, we've got a microphone. And Joni and Kelsey are still with us. So if it's about cyber breach, they'll answer the questions, or we can, and then obviously there's me and Emil as well.
It's not a question, it's more of a... Thank you first, Jamie Kelly. It's a very good, and rich and knowledgeable presentation or seminar.
Thank you. You're too kind.
Yeah. So I have just one note. One of the things that has been mentioned at the beginning of the presentation is about how to keep the data secure. So one of the things mentioned is to save them in cloud. But I just wanted to make a note that government entities and maybe also government companies, they can't transfer information outside of Oman, and that's restricted. But private entities, they can do so.
That's correct, yeah. And obviously those that can't transfer the information outside of the country because they're restricted to do so, and you're right, it's government agencies, you would be thinking that they're going to have off-site backup systems and different connections on that. So, yeah, it is. It all comes down to once you're, and Joni and Kelsey, hopefully they can still hear me, can jump in if need be, but it comes down to the point is that when you get your systems locked up and encrypted, you've really got two choices. Do we have a separate backup system that we can start running straight away, and therefore we're not too fussed about the ransom, or do we pay?
And oftentimes, with banks and big financial institutions, we do see that they do have data recovery centers that are separate from the systems that they're using day to day. And so that's another way to try and protect your backups. If, for example, you can't use a file.
Govinda. Oh, hold on a sec, sir.
Thanks, Jamie, and to the committee's team for that very insightful seminar. Given that we're in the Ministry of Justice and Legal Affairs, I wondered, does anyone have any idea when the regulations are coming out?
I never asked that question when I came here for a reason, but well done for you to. Is there anyone here in the ministry that has any idea when the regulations will be coming out? I'm assuming, although I could be wrong, that they will be hopefully before Valentine's Day next year, because I'll have something to read, because I don't think anyone's going to send me a card. Yeah, I don't think we've got anyone here on that one, but keep your eyes peeled. Sorry, I'll come to this gentleman up here.
Good morning.
Good morning. Can we put you on the microphone, because our guys...
My voice is...
No, but my guys in Hong Kong can't hear you, unless you're very loud, and Dubai. Then I'll come to you, this gentleman here afterwards.
Good morning.
Good morning.
Thank you for the seminar. I just wanted to know how we can differentiate or segregate between the personal data, what considered personal data, and what is not considered personal data. For example, let's say the name, the email, the mobile number, which is the people is already publishing it everywhere.
Yeah.
Their CVs everywhere is thrown, and it has more personal data that I would process. So how I can differentiate that?
Yeah, it's actually a really good question, and the answer now actually is in the law. So if you look at Article 3 of the law, this sets you out who who the data does not apply to. So I said like about national security. There are, one, two, three, four, there's 11 exclusions in there. There's then Article 2 that who it does apply to. One of those exclusions is that information that is already in the public domain. So that's but do get a copy of this law. If you want a copy in Arabic or English and you can't get hold of it, give us a call. We'll give me your email address and I'll email it to you. Because I can still do that until Valentine's Day. Yes, sorry, I'll come to you at last. Good morning.
For the presentation. So when we went through the law last February, we noticed something very interesting, and this is to compare to the GDPR. Under Article 3, the exclusion of where the personal data or personal data protection won't apply in the case of performance of a contract. So under the GDPR, that's one of the legal bases of the law. So let's say if I'm an employer, I can process certain categories of employee personal data that I need to fulfill my employment contract, or also to perform a legal obligation, to report to the Ministry of Labour or whatnot. But you foresee a scenario where you have businesses trying to use that to avoid the law. So let's say in terms of like service contracts.
Yep.
So let's say I'm a bank. I can try to obtain consent through my terms and conditions. I can just dump a bunch of information into a privacy notice that people may or may not read, and just try to circumnavigate the law.
I wouldn't say it's circumnavigating. I'd say that those, but you're right, those institutions are going to actually make sure, what's the easiest way to comply with these provisions? And obviously entering into a contract, you had already given them your details because you're entering into that contract. It doesn't matter if it's a personal contract with a bank, or you do it with a supplier. The guys that bring you your coffee pods for your Nespresso machine or whatever. If you go enter into those, you're consenting to that information. So they need to now go back to what they're doing at the moment and what those data processing is actually covered now. Check this law and to see if it complies. And it probably, and to some instances it will, apart from the whole thing about express consent. So they're probably going to have to change their wording. They're probably going to have to go out and revisit back their clients and say, do you still want to receive information from us? But it's not I don't think it's a question that they'll try to avoid the law, because I just think the penalties are just far too severe. And the test, particularly for did you get consent, it's a very low threshold to prove. So they'll be looking at their systems to say, how are we going to comply with this law? So I get the question. I think it's just a bit tilted, because I don't think we should go around saying we're going to avoid these things.
Okay, I correct myself.
Yeah.
That, according to my interpretation of the law, is that I don't need to seek consent if the personal data processing activity is happening within the context of performing the contract, which is included as an exclusion in Article 3.
Yeah, but what you've done in entering that contract, you've already given that data over. So that's right, and that makes sense, doesn't it? Is that we enter into a contract together. I know who you are. I know what information I needed to enter into that contract. Why would I now want to consent when I'm carrying on the contract with you? If I didn't know you and I wanted to get into a contract with you, and I'm going, right, I'm going to pinpoint this person because I want to do business with him, this is when this is going to start kicking in. And that's where I need your express consent. Yeah, sure, yeah, we'll be around. Lady over here in the white jacket. Thanks, guys. Good morning.
My name is Aarti.
Hi.
First of all, let me thank you for such a lovely seminar.
Oh, thank you.
So this query is regarding a website. If I'm starting a website, do I need to appoint someone as a data protection officer, like you said, or can I be myself the data protection officer? So is it mandatory that there needs to be a person specifically for that, or can the owner be the data protection officer?
The data protection officer can be anyone in your organisation, even if it's just yourself. Yes, it's akin, not entirely the same, but it's for financial institutions and also non-financial institutions under the AML law. We as lawyers have to appoint an anti-money laundering officer. So that could be me. It could, you know, if I was a one-man band, it would have to be me. So I'll be that person, and I'll be the data processor and the data controller. So the answer is yes to your question.
And also, if it's an online platform, as we were talking about the jurisdiction, do you think that should we follow the Omani data protection laws or the GDPR or the laws in California? Because I don't know, like, what is the jurisdiction?
All of the above. Go to what you perceive to be the most strictest law, or your lawyers advise you to what the strictest law, and apply with those. There may well be. I mean, you've got to comply with the Oman law if you're based here.